Hello again and welcome to the program. I am Suren. Let's talk about the laws about the anti-discrimination issues around the world and in Australia. Anti-discrimination laws vary globally through international human rights treaties like the Universal Declaration of Human Rights, UDHR, which provides a foundational framework for equal treatment. In Australia, national anti-discrimination laws, including the Racial Discrimination Act 1975, Sex Discrimination Act 1984, Disability Discrimination Act 1992, and Age Discrimination Act 2004 prohibit discrimination on specific grounds and are complemented by state and territory legislation. International anti-discrimination laws include Universal Declaration of Human Rights, UDHR, was adopted by the UN. This non-binding document set a universal standard for all people to have equal rights and freedoms, regardless of their race, color, sex, language, religion, political opinion, national or social origin, property, or birth. Legally binding treaties, the UDHR has inspired legally binding human rights laws that countries, including Australia, where it has been agreed to uphold. What do these include, would you say? Well, International Covenant of Civil and Political Rights, ICCPR. International Covenant of Economic, Social, and Cultural Rights, ICESCR. Convention on the Elimination of All Forms of Racial Discrimination, or CERD. Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW. Convention on the Rights of Persons with Disabilities, CRPD. Anti-discrimination laws in Australia include Commonwealth legislation. At the federal level, anti-discrimination laws include which prohibits discrimination based on race, color, national, or ethnic origins. Sex Discrimination Act 1984 protects against discrimination based on sex or sexual orientation, gender identity, and other related grounds. Disability Discrimination Act 1992 addresses discrimination against people with disabilities. Age Discrimination Act 2004 prohibits age-based discrimination. Australian Human Rights Commission Act 1986 establishes the Australian Human Rights Commission and provides a framework for human rights protection. State and territory legislation. In addition to federal laws, each Australian state and territory has its own anti-discrimination and equal opportunity agencies and legislation. These laws are based on similar grounds of discrimination but may also include additional provisions or have different exemptions. Overlap and employer responsibilities, both Commonwealth and state/territory laws generally apply, and employers must comply with all applicable legislation. It is crucial for employers to understand any exemptions or exceptions that may exist under different acts. The Australian discrimination laws include the following. There are federal, state and territory laws in Australia to protect people from discrimination and harassment. The Australian Human Rights Commission has statutory responsibilities under the Age Discrimination Act 2004, Australian Human Rights Commission Act 1986, the Disability Discrimination Act 1992, Racial Discrimination Act 1975, and the Sex Discrimination Act 1984. In addition to the federal legislation, each state and territory in Australia has equal opportunity and anti-discrimination agencies with statutory responsibilities. Commonwealth laws and state/territory laws generally overlap. However, the laws apply in different ways and employers must comply with all legislation. Employers also need to check the exemptions and exceptions in Commonwealth and state or territory legislation. An exemption or exception under one act does not mean employers are exempt under another act. Federal laws. The following operates at a federal level, and Australian Human Rights Commission has statutory responsibilities under them. Age Discrimination Act 2004. Human Rights Commission Act 1986. Disability Discrimination Act 1992. Racial Discrimination Act 1975. Sex Discrimination Act 1984. State and territory laws. The following laws operate at a state and territory level, which state and territory equal opportunity and anti-discrimination agencies having statutory responsibilities under them. What about Australian Capital Territory Discrimination Act 1991 and New South Wales Anti-Discrimination Act 1977, Northern Territory Anti-Discrimination Act 1992, Queensland Anti-Discrimination Act 1991, South Australia Equal Opportunity Act 1984, Tasmania, Anti-Discrimination Act 1998. Victoria, Equal Opportunity Act 2010. Western Australia, Equal Opportunity Act 1984. Human rights recognize the inherent value of each person, regardless of background, where we live, what we look like, what we think, and what we believe. They are based on principles of dignity, equality, and mutual respect, which are shared across cultures, religions, and philosophies. They are about being treated fairly, treating others fairly, and having the ability to make genuine choices in our daily lives. Respect for human rights is the cornerstone of strong communities in which everyone can make a contribution and feel included. The Australian Human Rights Commission has developed a sense of fact sheets, which provide essential information on the development on or of human rights law. Human rights treaties. The Universal Declaration of Human Rights, adopted by the United Nations on December 1948, set out the basic rights and freedoms that apply to all people. Drafted in the aftermath of World War II, it has become a foundation document that has inspired many legally binding international human rights laws. The Australian government has agreed to uphold and respect many of these human rights treaties, including, International Covenant on Civil and Political Rights, International Covenant on Economic, Social, and Cultural Rights, or rights, Convention on the Elimination of All Forms of Racial Discrimination, Convention on the Elimination of All Forms of Discrimination Against Women, Convention Against Torture and other cruel, inhuman, or degrading treatment or punishment, Convention on the Rights of the Child, Convention on the Rights of Persons with Disabilities. The Australian Human Rights Commission has a responsibility to monitor Australia's performance in meeting its international human rights commitments. They provide advice and recommendations so that these standards are reflected in our national laws, as well as policies and programs developed by the government. A Human Rights Act for Australia. Australia has strong sense of human rights and freedoms, but people's basic human rights are not very well protected in Australian law. Don't despair. Australia is the only liberal democracy in the world that does not have a national act or Charter of Rights that explains what people's basic rights are and how they can be protected. Some state territories in Australia have their own Human Rights Act, but Australia needs a national Human Rights Act to ensure that the rights of all people are protected, all of the time. The Australian Human Rights Commission has developed a model for what a national human rights act might look like, how it could function, and what it would do. Discrimination, complaints. Let's talk about it. The Australian Human Rights Commission investigates and conciliates complaints about discrimination and breaches of human rights. It does not act as an advocate or legal representative for a party to a complainant. The complaint process is simple, free, and flexible. Let's consider a list from the public sector guidance. Rights of equality and non-discrimination. What are the rights of equality and non-discrimination? Question mark. Equality affirms that all human beings are born free and equal. Equality presupposes that all individuals have the same rights and deserve the same level of respect. All people have the right to be treated equally. This means that laws, policies, and programs should not be discriminatory, and also that public authorities should not apply or enforce laws, policies, and programs in a discriminatory or arbitrary manner. Non-discrimination is an integral part of the principle of equality. You can ensure that no one is denied their rights because of factors such as race, color, sex, language, religion, political or other opinion, national or social origins, property or birth. In addition to those grounds, discriminational and other uncertain grounds may also be prohibited. These grounds include age, nationality, medical status, disability, place of residence within a country, and sexual orientation. Sometimes it may be necessary to treat people differently to achieve equality. This is because the differences between people may make it difficult for them to enjoy their rights without support. Different treatment may not amount to prohibited discrimination if the criteria for the differentiation are reasonable and objective, and if the aim is to achieve a purpose which is legitimate under the international covenant and civil and political rights. The right to equality and non-discrimination encompasses both positive and negative obligations. The obligation to retain or refrain from discriminating or eroding equality, and the obligation to protect and advance to fulfillment and enjoyment of the rights to equality and non-discrimination for all people. Where do rates of equality and non-discrimination come from? Australia is a part of 7 core international human rights treaties. The rights of equality and non-discrimination are contained in Articles 2, 16, and 26 of the International Covenant on Civil and Political Rights, ICCPR. When does one need to consider the rights or equality and non-discrimination? That's a good question to ask. You will need to consider the rights of equality and non-discrimination whenever you are working on legislation on a policy or a program that draws distinction between people or groups based on any of the following grounds. Race. sex, disability, or age. You will also need to consider the rights of equality and non-discrimination whenever you are working on legislation, a policy, or a program that draws distinctions between people or groups based on the following: color, language, religion, political or other opinions, national or social origin, property, one's birth, nationality, medical status, race or place of residence within a country, or sexual orientation. This includes direct or indirect distinctions and those that may have unintended consequences. For example, you will need to consider the rights if you are working on eligibility criteria governing financial benefits which differ according to sex or age. You should ask yourself whether your legislation, policy, or program provides for different treatments, and if so, whether the difference can be justified as reasonable or objective. Can the objective be achieved by non-discriminatory measures? You will also need to consider the right if you are working on a measure that assists or recognizes the interests of particular groups or individuals in the community, or maybe disadvantaged, such as Indigenous Australians. For example, measures to close the gap in life expectancy and opportunities between Indigenous and non-Indigenous Australians, including addressing the overrepresentation of Indigenous Australians in the criminal justice system. What is the scope of the rights of equality and non-discrimination? Discrimination is an permissible differential treatment among persons or groups that result in a person or a group being treated less favorably than others, based on one of the prohibited grounds for discrimination. In addition to the grounds specially enumerated in Articles 2 and 26, discrimination is prohibited on other states. UN Human Rights Committee has not attempted to define this term, but has decided it on a case-by-case basis. Among others, and the following statutes have been held to qualify as prohibited grounds: age, nationality, marital status, disability, place of residence within a country, and sexual orientation. Not all treatment that differ among individuals or groups on any of the grounds mentioned will amount to prohibited discrimination. Why Human Rights Committee has recognized that not. Every differentiation of treatment will constitute discrimination if the criteria for such differentiation are reasonable and objective, and if the aim is to achieve a purpose which is legitimate and under the covenant in determining the reasonable and objective test. The committee has proceeded on a case-by-case basis. For example, in a case involving Australia, the committee stated that the institution of a compulsory retiring age of 60 for airline pilots in the interest of maximizing public safety was a legitimate purpose under the ICCPR. Indirect discrimination. Discrimination may be either direct or described before, or indirect. Indirect discrimination could occur when a requirement or condition is neutral on its face, but has disproportionate or unintended negative impact on particular groups or persons. For example, a requirement for all employees to be over 6 feet tall before being employed in a particular industry, where there is no cogent evidence that a minimum height requirement is justified by the conditions in the industry, is not discriminatory on its face, but it would have an, let's say, a disproportionate impact on women, and less likely to meet the height requirement than men, and may therefore constitute discrimination on the basis of sex. Prohibited grounds for discrimination. Under Commonwealth law, the prohibited groups or grounds for discrimination set out in the Racial Discrimination Act 1975, Sex Discrimination Act 1984, Disability Discrimination Act 1992, and the Age Discrimination Act 2004. Each act contained provisions setting out what constitutes prohibited discrimination. For example, the Racial Discrimination Act provides that it is unlawful to do any act involving a distinction, exclusion, restriction, or preference based on race, descent, or national or ethnic origin, which has the purpose and effect of impairing the recognition, enjoyment, or exercise and an equal footing of any human right or fundamental freedom in the political, economic, social, cultural, and any other field of public life. This formulation is drawn from the definition of racial discrimination in the CERD. The other acts which contain different tests for what constitutes discrimination and also prohibit other conducts. For example, the Disability Discrimination Act enables the making of disability standards in relation to areas in which it is unlawful to discriminate and provides that contravention of disability standard is unlawful. Legal recognition. Article 16 of the ICCPR is to protect the right to be recognized everywhere as a person before the law. The UN Human Rights Committee has stated that the right in Article 16 is particularly pertinent for women. It protects their capacity to own property, to enter into a contract, and exercise other civil rights without discrimination. While Article 16 entitles a person to legal recognition, it does not extend to legal capacity to act in all circumstances. Limitations on the legal capacities to act of children or mentally ill persons would not violate Article 16. What about complaints? Well, complaints made under these laws may be investigated and conciliated by the Australian Human Rights Commission, and the complaint is, if the complaint is not resolved before the Commission. The complainant may apply to a federal court. In addition to these powers, the Commission also has a power under the Australian Human Rights Commission Act 1986 to investigate complaints about certain other matters. Unlike complaints made under the Racial Discrimination Act, Sex Discrimination Act, Disability Discrimination Act, and Age Discrimination Act, complainants about these matters are not able to apply to federal courts. They are breaches of the rights under the ICC, CPR, CRC, CRPD, and a number of other declarations and international instruments declared by the Attorney General. Discrimination in employment on the basis of race, color, sex, religion, political opinion, national extraction, social origin, sexual orientation, age, criminal record, trade union activity, medical record, medical status, disability, or impairment. The Fair Work Act 2009 contains numerous provisions protecting employees against discrimination in the workplace. The Act prohibits the inclusion in a modern award and enterprise agreement of terms that discriminate against an employee because of order-related reasons, including the employee's race, color, sex, sexual orientation, age, physical or mental disability, marital status, family or carer's responsibilities, pregnancy, religion, political opinion, national extraction, or social origin, unless the discriminatory term is due to the inherent requirements of a particular position, is due to the employment of an employee as a member of the staff of an institution conducted in accordance with a particular religion or creed, and is taken in good faith to avoid injury to the religious susceptibilities of adherents of that religion or creed, or relates to minimum wages for junior employees, employees with a disability, or employees to home training arrangements apply. The Act provides for review of a modern award and enterprise agreement referred to as Fair Work Australia by the Australian Human Rights Commission. The general protection provisions in the Act prohibit an employer from taking adverse action, which includes discriminatory action against an employee or prospective employee based on the person's race, sex, sexual orientation, age, physical or mental disability, medical status, family or carer's responsibilities, pregnancy, religion, political opinion, national extraction, or social origin, unless the action is not unlawful under any anti-discrimination law enforced in the place where the action is taken, because of the inherent requirements of the particular position concerned, or taken against the staff member of religion or creed, institution in good faith, and to avoid injury to the religious susceptibilities of the adherents of that religion or creed. Other conducts. Some Commonwealth anti-discrimination legislation also prohibits other types of conduct. For example, the Racial Discrimination Act prohibits acts that are likely to offend, insult, humiliate, or intimidate another person where the act is done because of the race, color, or national or ethnic origin of the other person. Special measures. In some circumstances, it is legitimate to take measures that assist or recognize the interests of particular groups in community who may be disadvantaged. These measures may seek to eliminate or diminish conditions which serve to perpetuate discrimination prohibited in the ICCPR and other human rights treaties. Such measures, sometimes called special measures, are specifically recognized in CERD to secure the advancement of certain racial or ethnic groups or individuals, and CEDAW to accelerate equality between men and women. Generally, such measures must be ended after the objectives for which they were taken have been achieved. For example, numerous indigenous-specific programs, which are aimed at addressing the underlying disadvantage confronting many indigenous Australians, will not qualify as special measures. Under Article 4 of the ICC-CPR, countries may take measures derogating from certain of their obligations under the Covenant in time of public emergency which threatens the life of the nation and existence or which is officially programmed. Such measures may only be taken to the extent strictly required by the exigencies of the situation, provided that such measures are not inconsistent with their other obligations under international law and do not involve discrimination solely on the ground of race, color, sex, language, religion, or social origin. Although Articles 2 and 26 are not listed among the obligations from which derogation is prohibited, it is clear from the terms of Article for Measure of Irrigation must not discriminate on the basis of any of the grounds listed in it. This from Article 16 of the ICC CPR is not permitted. The rights of equality and non-discrimination are an essential component of almost all other rights and freedoms. It would generally be prohibited to discriminate on the basis of any of the grounds enumerated in Article 26 of the ICC CPR within the laws, policies, and programs that give effect to other rights. Article from relevant conventions. Article 2. 1. Each state party to the present covenant undertakes to respect and to ensure to all individuals within its territory and subject to its jurisdiction the rights recognized in the present covenant without distinction of any kind, such as race, color, sex, language, religion, political or other opinions, national or social origin, property, birth, or other status. 2. We are not already provided for the existing legislative or other measures. Each state party to the present covenant undertakes the necessary steps in accordance within constitutional processes and with the provisions of the present covenant to adopt such laws or other measures as may be necessary to give effect to the rights recognized in the present covenant. Article 26. All persons are equal before the law and are entitled without any discrimination to the equal protection of the law. In this respect, the law shall prohibit any discrimination and guarantee to all persons equal and effective protection against discrimination on any ground such as race, color, sex, language, religion, political or other opinion, national or original social origin, property, birth, or other status. The Declaration of Human Rights from United Nations, peace, dignity, and equality on a healthy planet. The Article 12 mentions, no one shall be subjected to arbitrary interference with his privacy, family, home, or correspondence, nor to attack upon his honor and reputation. Everyone has the right to be protected of the law against such interference or attacks. Article 18 states, everyone has the right to freedom of thought, conscience, and religion. This includes freedom to change his religion or belief and freedom, either alone or in community with others and in public or private, to manifest his religion or belief in teaching, practice, worship, and observance. Article 19. Everyone has the right to freedom of opinion and expression. This includes freedom to hold opinions without interference and to seek, receive, and impart information and ideas through any media and regardless of frontiers. Article 20. 1. Everyone has the right to freedom of peaceful assembly and association. 2. No one may be compelled to belong to an association. Article 27. 1. Everyone has the right freely to participate in the cultural life of the community, to enjoy the arts, and to share in scientific advancement and its benefits. 2. Everyone has the right to the protection of the moral and material interests resulting from any scientific, literary, or artistic production of which is the author. A question has been asked. Can you sue someone for emotional distress? Someone who may also be just trying to do it. Answer. Yes, you can potentially sue for emotional distress if someone is consistent false accusations of being a liar cause you severe psychological harm, especially if it is part of a broad pattern of harassment and defamation. In Victoria, such claims fall under personal injury law, and you would need to provide clear evidence of your suffering and it is impacted on your life and it's impacted on your, according to lawyers, and you should also consider if the false accusations could amount to defamation. What steps can you consider? Good question. 1. First, seek medical and legal advice. Your first step should be to consult a medical professional for your emotional distress, and then seek advice from a personal injury lawyer in Victoria. They can guide you through the legal process and explain your options. This has been provided information from a lawyer. To gather evidence, you will need to collect evidence to prove the false accusations and a severe emotional and psychological harm you have suffered as a result. This could include documenting the incident of false accusations, obtaining medical records that show your condition, such as anxiety, depression, or trauma, demonstrating the impact of the stress on your daily life. Very important. 3. Consider the defamation. If the false claims of being a liar are made to a third parties, you may have a case for defamation. A lawyer can help you determine if the statements were false, caused damage to your reputation, and will communicate it to an audience. 4. Understand the legal threshold. Successfully for emotional distress requires meeting a high legal threshold, meaning the distress must be severe and debilitating enough to significantly impact your life. 5. Explore compensation. If successful, you could seek compensation for pain and suffering, as well as for the damage to your reputation if defamation is proven, no matter how long it might have taken. A day, half a day, 10 years, or thereabouts. Let's talk about defamation. A defamation case arises when a person or organization believes their reputation has been damaged by a statement or publication, and they take legal action against the person responsible, known as suing, for defamation. The material may be online defamation of character, like applications on websites or social media, more traditional forms of media, including news reports and newspaper, or even defamation by email or group chat messages. So, for defamation can be a lengthy and costly process. By engaging specialist defamation lawyers early, you can successfully resolve before proceedings commence, saving your time, money, and protecting your reputation and well-being. As I said, information is provided by lawyers. A defamation lawyer can assist in addressing and mitigating the risk of potential publications, ensuring you can convey information without under your risk of defamation claims being brought against you. Also, your defamation lawyer will provide advice and recommendations to ensure you can quickly and appropriately respond to publications that have improperly damaged your reputation. Again, the question is being asked, what is truly defamation? Question mark. Defamation is the publication of material that causes the ordinary, reasonable reader, viewer, or listener to lower their opinion of the person in question. Definitely, material does not need to be in mainstream media publications to be actionable. While the most high-profile defamation claims generally involve things published in the newspapers and sit on radio or said in radio or television, the material can be published in blogs, social media, posts, emails, cartoons, and online reviews, or in a small family gathering. Example: defamation of character can occur when a person makes an accusation of impropriety against someone else by implying they are a thief or liar about everything, or simply suggesting that they are someone to shun or avoid. Accusations of this type can cause damage to the person's character. Defamation law protects Australians from false and damaging statements. The law also provides mechanisms for remedy and award of damages for financial and reputational losses because of defamation of character. Defamation claims increased in recent years for a range of reasons. One of the most significant reasons is the speed, permanency, and accessibility of online content. Since the advent of Facebook, blogs, and online media, claims for social media defamation have increased significantly. Not all cases go to court. There are plenty of techniques to remove unwanted content. The lawyers have proven ability to manage defamation lawsuits efficiently and cost-effectively. Reputational risk. Defamation claims result from negative statements or publications, or reputational risk is when a gap exists between public perception and actual behavior. This is not to say people are necessarily acting contrary to the law, but rather they act in a very strange way that does not align with public expectations. For example, a business or individual acts in such a way that is legal but controversial, like implementing a process that is damaging to the climate or environment, or when an individual or a CEO has personally held beliefs misaligned to the general public, or misaligned, speaking about a person, downgrading. Defamation lawyers are risk experts. They advise you and your businesses on potential risk factors and can manage processes where a potential risk to reputation exists, develop crisis management plans, and initiate legal processes when necessary, or advise on the potential ramifications of business dealings or public statements. Removing defamatory material. Removing damaging online defamation, for instance, that sort of content, including social media posts, personal blogs, images, or false statements, requires specialist legal support. The ranking of these types of posts depends on your digital footprint, the amount of digital publications about you. The less publications, the higher these types of things will rank in search engines like Google. But despite the rank, the material can appear when people search your business or even your name, about your paintings, your exhibitions, for instance. Your defamation lawyer will work with you to remove unwanted materials, corresponding on your behalf to the original author by sending concerns, notices, or letters of demand, or notifying the secondary publisher or content host, like Facebook, to remove the publication. Or they will work with your business or public relations agencies to suppress the negative content with the reverse SEO, or search engine optimization. Reverse SEO is creating more content to increase your digital footprint. Responding to a defamation claim. Just because something you have said is disparaging does not necessarily make a claim actionable. Various defenses are available to defamation claims. Balancing the importance of protecting reputation is against the need for freedom of speech. Of course, your defamation lawyer can help with pre-publication advice. We can also make recommendations and formulate a response strategy if you have received a concerns notice. Our support will assist you to say that you need to say without getting sued. That is from a lawyer. Question: can you sue for emotional distress in Australia? Question mark. Emotional distress is invisible, yet its impact can be overwhelming. If you have been struggling with anxiety disorders, depression, or PTSD due to someone else's actions, you may be wondering, can you sue for emotional distress in Australia? The law recognizes that psychological suffering is just as real as physical pain, whether it stems from a traumatic car accident, workplace bullying, medical negligence, or a serious invasion or privacy. You may be entitled to compensation for the distress you have endured, even if it was an accusation of lying in a family gathering or friends gathering. For taking legal action is not just about money. It's about validation, closure, and reclaiming your life. Many clients have been helped find justice against their confidence and move forward. You don't have to go through this alone. No one does. Emotional distress does not always present itself in obvious ways. It can creep into your life slowly, affecting your mood, relationships, and ability to function. If you are wondering whether you might be suffering from emotional distress, here are some common signs to look for. 1. Psychological symptoms that may develop slowly. Persistent anxiety or excessive worry. Feelings of sadness, hopelessness, or depression. Frequent mood swings which can develop, or emotional outbursts. Flashbacks or intrusive thoughts related to a traumatic event, as being accused of being a liar. Difficulty concentrating or making decisions. That can happen. 2. Physical symptoms. Unexplained headaches, muscle tensions, or body pain. Sleep disturbances, insomnia, or excessive sleeping. Fatigue or lack of energy, even after resting. Changes on appetite, leading to weight loss or weight gain. Increased heart rate, sweating, or panic attacks, which can develop. 3. Behavioral changes. Avoiding social interactions and isolating yourself more. Increased irritability or possible aggression. Loss of interest in activities you once enjoyed. Engaging in self-destructive behaviors, such as alcohol or even substance abuse. Struggling to maintain relationships at work or whatever else. 4. Cognitive effects. Feeling overwhelmed, or constantly on edge. This can apply too. Difficulty remembering things or frequent confusion, self-doubt, or excessive guilt. Fear of situations that remind you of the distressing event, being accused as a liar. If you recognize any of these signs in yourself, it is important to seek professional help. Emotional distress can take a serious toll on your health, and you deserve support, not just through therapy and medical treatment, but also through financial compensation when someone else is responsible. Who can use suing for emotional distress? Many people assume that emotional distress is not something you can take legal action for unless there is a physical injury involved. But that is not always true. If someone's negligence or intentional actions have caused significant psychological harm, that may be held liable. You may be able to sue for emotional distress in Australia. They can be employees, drivers, medical professionals, business and property owners, individuals, institutions, and so forth. Let's look at individuals for a brief moment, shall we? If someone intentionally inflicted emotional distress through harassment, abuse, defamation, or other harmful actions, you may be eligible to pursue legal action for the psychological damage caused. Every case is unique, but there are certain situations where emotional distress claims are more common. Is gossip running your reputation? Or ruining your reputation, perhaps? Tips on using the law of defamation to help you. Has someone ever said anything so bad about you that you feel you need to take action? Have they lied about you or your business and caused you real harm? If so, the law of defamation might help you right these wrongs. Gossip and lies can do life to a person, their business, or even their mental and physical health. What is worse? The bad news always spreads faster than good. Here is a real life experience, an example. Imagine, I had a bad experience to authorize with a carpet company recently, and I told at least 6 or 7 people about it. But I had a really good experience with the trade person who built my carport, and so far I have only told one person, and that was my mom. This is a great example of just how fast bad news spreads. With such easy access to social media these days, rumors and lies spread even quicker, and more importantly, can have a real impact on a person's reputation or brand. If this has happened to you, what can you do about it? The law of defamation can help you. Defamation is the spreading and or saying of something that is not true, that damages a person's reputation or business brand. In New South Wales, you can claim compensation for the damage to your reputation or brand if you or your business has been defamed. Here is a short explanation of how the defamation rules work. Firstly, someone needs to defame or slander you. They could even write something bad about you on the internet or spread a lie about you in the workplace or in a gathering. What they actually say is legally called an imputation. 3 things need to occur for it to be classified as an imputation. 1. The imputation needs to be untrue or not allowed under the rules. These rules or circumstances apply to, say, some people who weren't allowed to say bad things about you and get away with it. For example, journalists can generally get away with saying more than most people, as what they reveal is in the public interest. Another example could be your boss doing a performance review of you in which he or she says less than flattering things. People are allowed to say things about you if they are actually true. But accusing you as a liar? No. However, if the imputation is untrue or is not allowed under the rules, you may have a case for defamation. 2. The imputation cannot be near verbal abuse. That sounds strange, as how can abuse be okay, but defamation not? Maybe it's because people take abuse less seriously. Let's take an imaginary example. Say a Mr. B runs a restaurant. If you make a general statement like, Mr. B is a complete idiot, people could say you are just angry with him. However, if you see Mr. B using food that is not fresh and it is a lie, that can be called defamation. The first statement about him being an idiot, they have a small effect on Mr. B's business. But the second statement could kill it. Who wants to eat at a restaurant that doesn't serve fresh food? That is exactly the same calling a professional artist a liar. Now think about why I say this. Because I have personally experienced it. 3. The individual needs to defame you to an audience. This has been also done only recently, and this is also very critical because this shows the extent of the damage. For example, if someone defames Mr. B to one person and it stops there, damage is limited to one potential customer. Or if they defame Mr. B in a newspaper that nobody reads it, probably means no real damage was done. However, if the same person tells the entire industry they are in social media or some other means that Mr. B serves bad food, then the damage is much more serious and could even cost his business to shut down. Remember, all 3 of these things need to happen for you to have a case for defamation. If they have, here is the steps you can take to build your case. 1. The first step is to issue a letter under the Defamation Act. You could think of this as just a letter, but its technical name is a concerns notice. This lets the defendant know you have been defamed, and details are as they have been said, demanding an apology and possibly compensation if there has been reputational and business damage. If you want an example of this letter to use, you can find it in the notice templates everywhere, even in Google. 2. If the behavior does not stop and no apology is given, the next step is to commence court proceedings. In this case, you are asking the court to ask the person to apologize and clear your name in addition to compensating you for the loss of your reputation and or business in monetary form. This is the damages part. So that is where we are at. Rights and concerns. We'll end this episode here now until we meet you again. Keep smiling. Be happy. Always. And thank you for watching.